Welcome to U.S. Immigration TV. In a previous video, I discussed some situations where marriage could affect the validity or waiting time for a petition. And I do invite you to go back and watch that video first for the first three items I discussed. In this video, I am going to be discussing more situations where marriage can affect a beneficiary's petition. So let's get right to it. Number 4, marriage destroys a beneficiary's eligibility as a derivative of their parent's petition. What do I mean by that? Well, most petitions include a person's minor children as derivative children, as long as they are under 21. For example, if a parent is petitioned as a married child or brother or sister of a U.S. citizen or by an employer, their children could also be included under that petition if they are under 21 years of age or they qualify for benefits under the Child Status Protection Act. However, if that derivative child marries, they may have married before their 21st birthday, they then lose the status of being a derivative child and are no longer included under their parent's petition. Number 5. Terminating a marriage converts the petition from F3 to F1. Now, if a child or beneficiary was originally petitioned as married in the F3 category, but their marriage is terminated through, let's say, divorce, annulment, or death of their spouse, the petition converts from F3 married child to F1 unmarried, where the visa could be available at least 10 years sooner than if they were married. Now, I've come across many cases where the beneficiary was petitioned as married, but they're now separated from their spouse, who perhaps abandoned them and now has a new family. There's no hope of saving that marriage. In that case, if the marriage is truly over and you go ahead and terminate the marriage, let's say through annulment or divorce, you can get your green card a lot faster in the F1 category, which is single child. However, I have to caution you, just as there is the concept of fixed marriage in immigration law, there's also the concept of fixed divorce, or where people who are truly in love terminate the marriage just so that the beneficiary can be classified in the faster F1. Number 6, if there are any changes in your marital status, it is important to notify the USCIS, the National Visa Center, or the embassy so your petition can be properly reclassified in the appropriate category. For example, if you were petitioned as married and your marriage is now terminated, but you don't let the NVC or USCIS know, they're going to keep your case in the married category rather than reclassifying it in the faster F1 category. In that case, you'd have to wait many more years beyond the time that F1 is current. As you can see, marriage can have a significant impact on a petition, which includes voiding the petition in certain circumstances, increasing the waiting time, speeding up the waiting time, etc. If you have any questions or issues about a beneficiary marrying, I would strongly suggest that you consult with an attorney, and obviously you should consult before you walk down the aisle. I hope you have found this video informative or useful. Remember, there's 2 parts, so don't forget to watch part 1 as well. And I will continue posting videos which I hope you will find useful and informative for you or your family or your friends. Therefore, make sure to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.